Hello everyone, I am Dr. Sonika Sharma from Shahid Bhagat Singh College, University of Delhi. I extend a warm welcome to all the students watching today's lecture. I shall be covering the topic buyback of shares and sweat equity shares today. Now, buyback of shares, it means the purchase by a company of its own shares or of its subsidiary. The shares are generally purchased at a price which is higher than the market price of those shares. It is governed by Section 68 of the Companies Act 2013. The buyback of shares, this provision was first introduced in the year 1998 under the Companies Act 1956, and then a similar provision was made in the Companies Act 2013. What exactly is the rationale for buyback? Basically, buyback increases the wealth of shareholders, reduces the cost of capital, improves promoters' stake in the company, and also leads to capital formation. Now, how it increases the investors' wealth? When the shares are bought back, it reduces the number of shares and thus increases the earnings per share. Also, the buyback price is higher than the market price of shares, hence investors gain by way of return of capital. Some of the examples of buyback in past years are the buyback by Tata Consultancy Services and Infosys. Then the second rationale behind buyback is reduction in cost of capital. The buyback of shares helps the company restructure its debt equity ratio. The percentage of debt which is a cheaper source of finance increases in the capital structure, and therefore the overall cost of capital is reduced. Then the third rationale is improving promoters' stake in the company. See, the percentage stake of the promoters increases in the company as the shares in the hand of general public decreases, as a result of which the hostile takeover bids can also be prevented. So, it is a very important measure as far as improving promoters' stake in the company is concerned. Then the fourth rationale behind buyback is capital formation. It leads to the capital formation as investors can make fresh investments with money back in their hands. And as all of you know, capital formation is the engine of growth of any economy. This is about the rationale of buyback. Now, the next we come to funds for buyback. A company may purchase its own shares or other specified securities out of various sources. The first is free reserves, the second is securities premium account, and the third is proceeds of the issue of any shares or other specified securities, provided that no buyback of any security shall be made out of the proceeds of an earlier issue of the same kind of securities. And when we talk securities, employee stock option plan are included in the specified securities. So, they can also be bought back like any other security. Then the next provision is transfer to capital redemption reserve account. Now, in case the shares are bought back out of free reserve, then according to Section 69 of the Companies Act 2013, an amount equal to the nominal value of shares shall be transferred to capital redemption reserve account, and the same shall be used for issue of fully paid up bonus shares by the company, and this is what has been provided in the SEBI guidelines. And the same should also be disclosed in the balance sheet of the company. It is a mandatory requirement to disclose it in the balance sheet. Then there are certain conditions which need to be fulfilled for buyback of securities. It is given in Section 68 of the Companies Act 2013. The first is the buyback has to be authorized by the articles of the company. Once it is included in the articles of association, then another resolution has to be passed whenever the company has to buy back shares. However, if the buyback is up to 10% of the paid up capital and free reserves of the company, a board of directors resolution is enough. There is no need for the company to pass a special resolution. Only if the buyback is more than 10% of the paid up capital of the company and free reserves, then it needs to pass a special resolution. Then the third condition is that buyback should not be more than 25% of paid up capital and free reserves of the company in any financial year. So, this is the maximum a company can buy, 25% of the paid up capital and free reserves, and if it has to buy more than 10%, then special resolution is to be passed, and if not more than 10%, then even a board of directors resolution will suffice. Then the fourth condition to be fulfilled for buyback is that the ratio of debt should not be more than twice the paid up capital and free reserve of the company after the buyback. So as to mean that the debt should not be too high as compared to the equity. Therefore, this provision has been made that the ratio of debt should not be more than twice the paid up capital and free reserves of the company after the buyback. If it is more, then the company cannot buy back. It can only buy back up till the ratio is not more than twice. Then the fifth requirement is that securities to be bought back should be fully paid up. Partly paid up shares and other securities cannot be bought back by the company. The next is that the buyback of securities which are listed on a stock exchange should be according to SEBI guidelines, whereas the buyback of securities which are not listed on the stock exchange should be according to the prescribed rules and regulations as given in the Companies Act 2013 and the guidelines which are issued from time to time. No buyback has to, within 1 year from the date of closing of previous buyback offer. Once the previous buyback offer has closed, no new buyback can be made within a period of 1 year from the close of the previous buyback offer. And the buyback has to be completed within 1 year of passing of special resolution or board of directors resolution as the case may be. So there are two things in that. In this, that buyback has to be completed within 1 year of passing a resolution, means once you pass the resolution, you can take 1 year to complete buyback and not beyond that. And the second thing is that once the resolution is passed and the buyback is closed, the buyback offer is closed, then no new buyback can be made by the company for another 1 year from the date of closing. Then the next is that after board's resolution or special resolution as the case may be, a declaration of solvency in form SH9 has to be made with the registrar and also with SEBI, that is Securities and Exchange Board of India. In case the company is not listed on the stock exchange, then only declaration of solvency with the registrar is enough. There is no need to declare solvency to SEBI. Then the declaration should state that the company would be able to meet its liabilities and will not be rendered insolvent in the next 1 year from the date of declaration. It has to be signed by at least 2 directors of the company, one of whom shall be the managing director of the company. So this kind of declaration of solvency is necessary, wherein the company has to declare that it will have enough capability, enough funds to meet its liability and will not be insolvent within the next 1 year. Only then it can buy back its shares from the market. Then the next is physical destruction of securities. This is given in section 68 subsection 7 of the Companies Act 2013. Physical destruction of securities means the company should extinguish and physically destroy securities within 7 days of the completion of buyback. Actually, physical destruction of securities is relevant only to the securities which are in physical form, like the share certificates. But nowadays we rarely find share certificates. Securities are more in the form of an electronic thing. So therefore, if it is in electronic form, then it has to be extinguished, meaning thereby that it is no longer in existence. And if it is in physical form, then it has to be physically destroyed. Then a register has to be maintained of securities bought back in form SH10. This provision is given in section 68 subsection 9 of the Companies Act. The register should be regarding consideration paid, date of cancellation and date of physical destruction, etc. These details have to be maintained, written in this register, which has to be maintained by the company in form SH10. Then the next is filing of return with the registrar and SEBI. So the company is required to file a return with the registrar and with SEBI in case in form SH11 within 30 days of the completion of buyback. So that return is essential, and the return should actually, it is not required to file the return with SEBI in case the securities are not listed on the stock exchange. The return is actually a document which mentions the details of the securities, what securities have been bought back, at what price they have been bought back, and various details are to be mentioned, and this return has to be filed with SEBI as well as the registrar of companies. And if the company is shares are not listed on the stock exchange, then there is no need to file such a return with SEBI. The company should only file it with the registrar of companies. Then the next thing is notice for the meeting. Section 68 subsection 3, the notice of the meeting should be sent at least 21 days before the meeting, in which a special resolution is to be passed. It should contain an explanatory statement as well. As all of you know that whenever a notice for a meeting of shareholders in which a special resolution is to be passed, an explanatory statement has to be attached detailing the various points of each of the special resolution, and likewise here also a special resolution has to be attached, and the special has to be attached, the explanatory statement has to be attached with the special resolution, and the explanatory statement should disclose, should have a full and complete disclosure of all the material facts. Secondly, it should outline the necessity for the buyback, the justification why the company is buying back the shares. Then it should state the class of shares or securities intended to be purchased under the buyback, that should also be mentioned. The amount to be invested under the buyback, how much the company is willing to spend on the buyback of shares. Then the lastly, the time limit for completion of buyback is also to be mentioned. See, basically the reason why explanatory statement has to go with the notice of the meeting is that all the shareholders have to be pre-informed, so that they come knowing the facts of the proposed resolution, and they should take an informed decision. That is why there is a necessity in law that these things should be outlined in each of the notice calling the meeting wherein special resolution is to be passed. Now also Rule 17 of Companies Share Capital and Debentures Rules 2014 says that the explanatory statement must also contain disclosure such as date of board meetings at which buyback was approved, objective of buyback, basis of arriving at buyback price, a confirmation that no default are subsisting with respect to repayment of deposits by the company, interest payment by the company on the deposits, redemption of debentures or payment of interest on those debentures, redemption of preference shares or payment of dividend on the preference shares to any shareholder, or repayment of any term loan or interest on any term loan to any financial institution or banking company. Meaning thereby that the company should not be defaulting on any of these payments, whether it is interest on deposit, whether it is interest on debentures, whether it is redemption of debentures, whether it is redemption of preference shares, or whether it is payment of interest on preference shares. The company should not have defaulted on any of those. That declaration, that detail should also go with the explanatory statement going for the for calling the meeting. Then the next is buyback from where? From whom actually? Buyback whom should from whom the company should buy back the shares. According to section 65 subsection 5 of the Companies Act 2013, the company can buy back shares from the existing security holders. It can buy back shares from the open market also. And it can also purchase the securities issued to employees under the employee stock option plan or sweat equity. Employee stock option plan is an option given to the employees of the company wherein they can buy the shares of the company. Sweat equity on the other hand is means shares issued to the employees and directors of the company for providing some technical know-how, some intellectual property rights, means some exemplary work done for the company. Now, if when it comes to buying shares from existing shareholders, it is done through tender method. Under this method, the company fixes a price at which it wishes to buy back a specified number of shares from the shareholders. If the number of shares offered for buyback at the stated price is more than the number of shares to be bought back, then the shares are bought back from each shareholder proportionately. In this method, every shareholder, including the promoter, has the right to participate. So, this is basically what tender is, that the price is fixed and the shareholders can sell their shares to the company at that price fixed by the company. Then the second is buying of shares from the open market. The company can purchase shares from open market at a price discovered through reverse book building process. So, in this reverse book building, the price is not already fixed by the company as it happens in tender method. In this method, the price is actually discovered through a process known as reverse book building. In book building, in reverse book building, the company specifies a price band, say between rupees 40 to 45. In this price range, the shareholders bid. After receiving the bids, the company selects the offered price from the lowest price onwards, at which the cumulative number of shares offered equals to or exceeds the maximum number of shares the company proposes to buy back. So, basically, so to say, the bids are invited from the shareholders at which they are willing to buy the shares of the company. At which they are willing to sell the shares to the company, and there is a price band which is already prescribed by the company, and the shareholders have to bid within that price band, that at what price they want to sell their shares to the company, and the company will, based on their bids, the company is going to choose the price which clears all the securities they want to buy. Then the next, there is moratorium on fresh issue. It is given on in section 68 subsection 8 of the Companies Act. Now, there is a prohibition on fresh issue of securities after buyback for a period of 6 months, which means that company is not allowed to issue fresh securities after buyback for a period of next 6 months, except by way of, it can issue securities by way of bonus shares. It can issue securities by way of sweat equity shares, that is allowed. It can convert its share warrants or stock options into shares, that is also allowed if they are due to be converted. Then it can convert its preference shares or debentures into equity shares. These kinds of conversions or issue of bonus shares or issue of sweat equity shares, they are allowed. Otherwise, the company cannot make a fresh issue of securities for the next 6 months after the completion of the buyback. Then there is a penalty for default also, which is given in section 68 subsection 11 of the Companies Act. Penalty is on the company also, and penalty is on every officer of the company for the default, if any, committed by company or its officers in complying with the provisions of the Companies Act relating to buyback. Penalty on the company is a fine ranging from 1 lakh to 3 lakh rupees, whereas penalty on every officer in default is imprisonment for a term which may extend up to 3 years, or a fine ranging from 1 lakh to 3 lakh rupees, or both. See, whenever it comes to penalties under the Companies Act, there is a penalty on company also, there is a penalty on every officer also, and as far as penalty on company is concerned, it is only a monetary penalty, and as far as penalty on every officer in default is concerned, it can be monetary and also imprisonment. Reason being, the company being an artificial person cannot be imprisoned, therefore it only has to only monetary penalty has to be imposed on the company, whereas every officer of the company, if the fault is grave, the officer can be imprisoned also, and if it is not so grave, there can be just monetary penalty, or there can be both monetary as well as imprisonment. Then the next is prohibition of buyback. According to section 70, a company cannot buy back its securities through a subsidiary company, including its own subsidiary. It cannot buy securities through subsidiary companies, any subsidiary company, including its own subsidiary. Then it cannot buy back securities through an investment company. Then also, if a default is made by the company in repayment of deposits or interest payable on the deposits, or redemption of debentures or preference shares, or payment of dividend or repayment of term loan to any financial institution or bank, then the company cannot buy back its shares. However, the buyback is not prohibited if the default is remedied and a period of 3 years has elapsed. So, once the company has defaulted in any of these things which I just mentioned, then it cannot buy back the shares, but it can buy back if the default has been corrected, has been remedied, and a period of 3 years have elapsed since the correction of that default. Then after 3 years it can buy back its shares. So, now we have the next thing, which is hollow buyback. Hollow buyback, sometimes the companies make buyback announcements and lift share prices, but later on they do not buy any share or spend just a fraction of money announced for buyback. This is known as hollow buyback. Now, to regulate such a hollow buyback, SEBI has issued buyback regulations. According to these regulations, the companies have to mention the minimum number of shares to be bought back while making announcement for buyback. Also, buyback offers should not be closed before the minimum number of shares are bought back. So, this is what hollow buyback is. Hollow buyback basically is when the company announces buyback and thereby lifts the prices of shares, but once the prices of shares are lifted, it does not, basically the intention of the company in these kinds of buybacks is that it does not want to buy the shares or wants to spend just a minimum amount in buying back the shares. The main purpose is to just lift the prices of shares. Therefore, they go in for a hollow buyback, and this is something, obviously this practice is wrong and is not in the interest of the shareholders of the company. Therefore, to check on this, the SEBI has introduced certain regulations, and the companies have to now mention a minimum number of shares which they will be buying back while making the announcement for buyback itself, and also buyback offers should not be closed before the minimum number of shares are bought back. So, this is how hollow buyback can be checked by the companies. Now, in fact, this is all about we have for today as far as buyback of securities is concerned. Let me just recapitulate it to you again. Buyback, as I just mentioned, is the purchase by a company of its own shares, and normally the shares are purchased at a price which is higher than the market price of shares. Obviously, if the price is not high, the shareholders will not be willing to sell. Therefore, buyback is done at a price which is higher than the market price of shares, and this particular provision of buyback was actually introduced in 1998, and it has continued to the Companies Act 2013 as well. And the rationale for buyback is that it increases the wealth of shareholders, reduction in cost of capital, improving promoters' stake in the company, and capital formation. Therefore, buyback you can say is something which is good for the company and good for the society as well in general. The company can use the funds for buyback from the free reserves, from the share premium account, or from the proceeds of the issue of any shares or securities already done by the company. Okay, but no buyback can be made from securities of the same kind which have been issued by the company. And when I talk about securities, I mean employee stock option plan also, which is included in specified securities. Then some amount needs to be transferred to capital redemption reserve account if buyback of shares is done through free reserves, and also it should be disclosed in the balance sheet of the company, and it can be used to issue fully paid up shares, bonus shares by the company to its shareholders. And buyback has to be authorized by the articles. These are the conditions for buyback. A special resolution needs to be passed if buyback is more than 10% of the paid up capital and free reserves, and but the company cannot buy back shares of more than 25% of the paid up capital and free reserves of the company, that is the maximum limit. And if buyback is less than 10% of the paid up capital in free reserves, then only a board of directors resolution is enough. There is no need to pass a special resolution. Then the ratio of debt to equity should also be maintained. It cannot be more than twice the paid up capital and free reserves of the company, and that is another requirement. Securities have to be fully paid up. The buyback of securities listed on a stock exchange should be according to SEBI guidelines. Buyback has to be completed within a period of 1 year. This is a requirement. Then a register has to be maintained. Then physical destruction of securities which are bought back is mandatory. A return has to be filed with the registrar of companies. Then notice has to be given of the meeting along with explanatory statement. Existing security holders can sell to the company in a buyback. Open market, from open market also the company can purchase. Then it can purchase securities sold to employees under employee stock option plan, that can also be done. Then there is a moratorium on fresh issue of securities for another period of 6 months, except for bonus shares, sweat equity, conversion of warrants into shares, stock options into shares, and all, etc. Then company cannot buy back through its subsidiary company or any other subsidiary company for that matter, or through an investment company. And also it cannot buy back if it has defaulted in any of the payment of dividend, interest on deposits, or redemption of debentures, or redemption of preference shares. For a period of 3 years, it have to elapse once the default is corrected. And then we did about hollow buyback, which is when the company just announces buyback to increase the price of shares. So this is all we have, and I hope all of you have understood the buyback thoroughly. So with this, I come to the end of the lecture. I hope you have been able to understand and absorb what I have taught you. Keep reading, keep learning. Thank you.